got a couple of questions here that I want to get to before we start to wrap things up. Joshua, this first question was for you, and it was just asking, what do you feel is likely when it comes to the future of funding itself? So that question dropped in while you were speaking there, Joshua. It's open to all of our panelists as well. Just asking for a forward look. What does the future hold when it comes to funding itself?
It's difficult to predict exactly what the future looks like, but I think that the broader legal litigation market provides you with a model of what the future of funding is likely to look like as well. I think that you will get, funding that is crucial to certain business models, that bridges sort of the risk tolerance between litigators and the clients. And I think that you will get different kinds of funding for very large law firms and very large clients, and you'll get different funding for much smaller clients and in different areas. One area that I think I can be a little more specific about is to say, even in large law firms, these business model decisions are being made on multiple different levels, right? A funder is saying, I'm investing in however many dozens of different litigations in order to spread out my liability. And even a law firm, if it's not purely plaintiff side, but is opening up a plaintiff side practice, can say, well, we're gonna do a bunch of different plaintiff side matters, and so we'll spread out our risk there as well. But for the individual partners who are working on those cases, frequently they don't get the benefit of this diversified risk. An individual partner, even at a large firm, may only be working on a couple of plaintiff side matters or funded side matters at a time, and it could have a material impact on their compensation. And so I think where you're going to see a continuous need for funding is in bridging gaps between risk tolerances, but also appetites, both between individual lawyers and their law firms, and between individual lawyers and law firms and the client.
Thank you so much. And Nicholas, this question dropped in while you were speaking, and again, it's open to everybody here. And it's a two-part question. The first part of which just asking, do you find that adversaries typically voluntarily disclose, funding information when it comes to having, seeking litigation funding? And does the presence of that litigation funding, have you found that it can be obstructive when it comes to finding a settlement?
So those are good questions. I typically find that in many cases, a lot of counsel will definitely resist, disclosure of anything as far as hard data or the, certainly, a copy of the funding agreement, which is a key piece of evidence. That's going to be, they're never going to disclose that voluntarily. But however, I have had plaintiffs more than once voluntarily disclosed during a deposition the fact of just that they do have funding in approximate amounts without an objection by the plaintiff's attorney. I've had that, just anecdotally happen, on a couple of occasions. As far as whether it's an obstacle to settlement, I think that there are some cases where that's true. It's hard for us to know exactly because, it's sort of a chicken and egg problem where if you don't have disclosure, you don't know what's going on. And if, and you can't get it because you need some type of disclosure in order to start that process as a basis for getting more. So you often are not going to know what's happening. But we certainly, with high interest rate loans in certain cases that are very difficult to settle, we definitely believe that that could be a factor in making it harder to resolve a case.
Just one comment on settlement, which is that a funded litigation is typically non-recourse. Certainly, all of the litigation funding that I think we've been talking about today is there's an assumption of non-recourse funding, which means that if the litigation loses, the funder loses their entire investment. So the funder doesn't control settlement, and so they can't make these decisions. But if there is a motivation there, settlement is a good outcome for a funder. It takes their risk off the table and gives them their return, which otherwise they stand a real risk of losing their entire investment.